Welcome back to TASS TV Melbourne. Well, this is a special case for me personally. Pattas, me versus Stonnington Council in 2010. This case went to the Supreme Court. We won the appeal. It nearly ended up in the High Court, but we settled before that. It's a famous land tax case that has been used as a case precedence for many land tax cases since. And it has to do with heritage overlays and the impact of planning schemes on development potential of land. Listen on. Okay, this is the subject property here. It's called the Colosseum, and the actual shop itself is the cash converter shop. It was cash converters back in 2010 as well. So those tenants still remain there, but that's the subject property, and this is the subject building called the Colosseum. It was built in 1914 and a building with great social, architectural and historical importance. It's been classified under the Stonnington planning scheme as an A1 building, which has national, and it means it has national and state importance. It's also on file in the Register of the National Trust. It's not listed, but it's on file, and stands between the former Conway store, so that was a retail department store, that building there. And it also stands on the other side. On the other side, it has a double-storey Italianate building dating from the late 19th century. So the significant heritage facade that you see here of the property means it has it's got little value as a potential development site as it stands, but it's not heritage listed. It's not on the register, but it's been nominated to be. Okay, and it was back in 2010. Okay, this is the development from the rear. As you can see, it's not a corner site. We're in the laneway. It's what we call an inside block, and inside blocks are more difficult to develop. And that's the Conway building on the right side. Looking from the front, it has a heritage overlay, and also the Italianate building on the other side. As you can see, it doesn't stick up from the parapet. The parapet's really, really important, and I'll come back to that later on. So what Carl Kundal from Valuate did is he assumed that this building wasn't under the Valuation of Land Act. He just assumed that the building wasn't there, which was correct, because under the Valuation of Land Act, the only time you have to assume the building is there if it's listed or if it's had a demolition order that was rejected. So he didn't. There were no errors there in terms of there were no errors in terms of the practice of assuming that the building wasn't there. He looked at this site, which is 2,780 square meters, and he applied a rate which resulted in a valuation of $14.278 million. Now, the issue for me is, as you can see, it's got a very low building coverage ratio because, as I said, in 2000, this was subdivided into 5 ground floor shops and 16 upper level apartments with rear parking. So what happens is the valuer applies a rate over 2,780 square meters, and because there aren't many units on this site, I'm left with the liability. I think I had an 11.3% liability, and therefore I'm required to pay 11% of the land tax value. So here we had a situation where the valuer simply applied a rate, and we'll come to that in a minute. The value came in at $14.278 million. I was left with 11.3% of that, and obviously I objected to the way the property or the rate that was applied to this property. But as you can see, it's not a fantastic development site because of the parapet at the front, because of the parapet wall on this particular building, on the building here on the left-hand side, and also the building on the right-hand side. The amount of height you would get on this site would be restricted possibly to 5 levels. It's common knowledge, of course, that there's a direct relationship between project-related site value and height. So obviously the greater height you can get on a development, the more apartments, the greater yield, the greater the gross realisation, and the higher the underlying value, the project-related site value. In this particular case, even if we assume that the building wasn't here, you've got the Conway building here, which is only, from the rear here, you can see it's only 3 levels, right? I think it's 3, yep, only 3 levels. And you've got the Italianate building there, and you've got the parapet. So obviously the parapet wall along the front there, you would be restricted, even if this was a vacant site, restricted to how many apartments you could have, or the height of the building. Now, the height would be a lot higher back here, so to the rear of the property. So the building would be recessed back considerably, and therefore reducing the total amount of apartments. There'd obviously be issues with light as well, so you would need to design the building in such a way to allow more light, which we proposed a horseshoe design would be the most ideal way. The block is fairly long, so overall you can see that it would be quite challenging for a developer, firstly to develop this site, but also secondly to achieve significant profit. The gross realisation, the end value, would be a lot lower than a site that had no restrictions at all. All right, so you can see the shop, cash converters there. And what I want to do now is I want to walk over to the most comparable sale that was used as evidence for this case. And interestingly enough, it's the Lululemon site here, Lululemon site. Also I want to talk about this development here. So you can see here, this is a 1930s facade, and the council obviously require this facade to remain. There's development going on to the rear, but you can see how the apartments to the rear recess back, and they're not too high. There are only maybe 1 or 2 apartments above the parapet, which means that there are restrictions in relation to building where you have a heritage facade, right? So there you can see the apartment there. All right, so that's what I'm talking about. So where you have a heritage facade, you've got restrictions, and you can see there they don't jut out too much above the facade. So the council don't mind modern development, but what they do mind is that you're not making the facade the main feature of the building. So the facade needs to be the main feature, and obviously the apartments need to be recessive to the rear. They can't jut out. Now the building I want to talk about, the development I want to talk about is this one here on the corner, Lululemon. At the time, there was no development here. You can see the apartments to the rear. Well, they weren't here at the time. And this particular site was used as comparable evidence, and I'll run through the numbers now. Funny things happen, and as it happened, I actually ended up purchasing this particular corner shop, the Lululemon shop. So, and you can see it's very, very close to the cash converter store. And I just want to run through the numbers with you. This was the only comparable in all the comparables that I think was relevant. And you can see the proximity to the building. But this here also had a heritage overlay. It's 264 Chapel Street in Param. It had a heritage overlay as well, so that was good. So both comparable in terms of that. And the properties weren't listed on the register, so that was good. However, this particular building had a C classification versus an A1 classification, meaning that this building wasn't as important to the council as the Colosseum facade. Now, despite that, you can see they didn't build above the facade. There was recessed back quite a bit, and the development was an 8-level development that was subsequently built. And this was what we call a hybrid sale. And why is it a hybrid sale? Well, this particular site sold for $7.5 million back in May 2007. It was sold for a couple of $1 million more than that a few years later. But at the time, it was a hybrid sale. Why? Because it was getting around $247,000 a year in cash flow. Now, the problem with a lot of these development sites, as you know, when they're vacant, the developer can't deduct any interest, and every minute they're losing money, right? In this particular case, the developer could sit on cash flow until they were ready to develop. Herein lies the problem. The problem is that, firstly, Carl Cundall from Valuate, the valuer at the time, I think these valuers spend very little time on these addresses. Now, I'm guessing he may have inspected it subsequently, but a lot of these valuations are done electronically. They don't really get paid much, even if they inspect the site. And at the time, I think what he did was he simply looked at this sale and said, look, that block of land there's a lot bigger, a lot larger, and just applied a discount rate without even thinking about anything. And really, I don't think much work goes into these valuations, not much at all. The council try and keep these valuations low to avoid objections, but really, they're not really thinking about the highest and best use in a way that someone would. Now, when they apply a value to these sites, so the Coliseum site, the valuer would have applied a value, assuming the building wasn't there, and the value would have related to the highest and best use. And the highest and best use, I think, they would have felt was a development site. They simply looked at this and said, okay, here's a development site, there's a development site, let's apply a rate. And they simply applied a rate per square metre. But that rate per square metre did not represent the real value, I don't believe, of the Coliseum site. Now, the Coliseum site, ultimately, they applied a value of $14.278 million. And I objected to that value. I had to pay around 11.3% of that. Or the site value that was applicable to me was about 11.3% of that. That was my liability. I objected to that, and of course the value that I proposed was $8 million. Okay, a few things that are really important in this case. So under the Valuation of Land Act, there are two reasons why a valuer under the Act would need to consider that the building stays and remains, and they can't assume a vacant site. One is if the building is heritage listed, it's on the register, or two, if there's been a demolition order that's been refused. In those cases, the valuer needs to assume that the building stays. Now, you and I know that if we ever tried to demolish this building, it would never happen, especially a building that's classified A1, that's so significant as the Coliseum building. But hypothetically, let's assume if there was no building on here and there was a vacant site, the valuers would still need to take into consideration the buildings adjoining, okay? The Conway building and the Italianate building, they form restrictions on the site, and that site would be restricted in many ways. Firstly, in terms of height, they wouldn't be able, like you've seen with the 1930s facade here, the apartments wouldn't be able to jut up a lot higher than the parapet wall. They would need to be recessed back. In other words, the height would need to be more to the rear. There's developments to the rear, there's issues with light, the shape of the block, it would probably need to be a horseshoe design, etc. So all these things work against the developer. So as well, it's not a corner site. So a developer that's looking at this site wouldn't necessarily be seeing the same value on this site that it would see on the other side. So just because it's close in terms of proximity, just because it's larger and has a rear laneway, it doesn't automatically justify a rate that's discounted only for size. A valuer should always take into account the planning restrictions and the heritage restrictions that are there on neighbouring properties. It's very, very important to think about neighbouring properties when you're looking at the value of a site. So when determining a project-related site value for this site, assuming it's empty, one needs to be mindful of that. And of course, Carl Cundall wasn't. I'm not even sure if he inspected the site. And even if he did, they certainly don't earn a lot of money in valuing these type of sites, and therefore they don't pay a lot of attention to these type of things. Now, the whole valuation practice nowadays is to try and have the values be a little bit discounted, so there are no objections, because ultimately the revenue from land tax goes to the state government, not to the local government, but the local government wears a lot of the legal cases. So this legal case I'm quite proud of. Hopefully I can tell my kids one day, my kids I've already told. And it's a famous case, a famous Supreme Court appeal. Didn't actually go to the High Court, but it's used. has been used in a lot of cases since, like the GPO case and the case that I recently discussed on St Kilda Road. So look, I'm sure there'll be changes in the future, but I'm really proud that I've contributed somewhat to the taxpayers of Melbourne. Hopefully I've saved them a little bit of money, both now, in the past and into the future. Thanks for listening. Okay, hope you enjoyed that video, a little trip down memory lane. That's Pattas versus Stonnington Council, 2010, a successful appeal to the Supreme Court. Effectively, it reduced the overall site value by 25%. That was the end result. It could have gone to the High Court, but I pulled out and we agreed out of court. Now, this case is often used for inflated valuations, for excessive site valuations, site values, and where the land tax assessments, where council or the valuer general assumed unrealistic development potential for a site. The key takeaway is if a planning overlay materially restricts redevelopment, the valuation must reflect that restriction, and it's still used today. The decision is still cited in Victorian and valuation law today, especially in VCAT land valuation matters, Supreme Court valuation appeals, and land tax objections, cases that involve the heritage overlay and issues in relation to heritage. So I'm excited to bring it to you. It's a very, very important case for me personally, and I think hopefully it's helped a number of Victorian taxpayers here and into the future. Thanks for listening. For more great content like this, please hit the subscribe button and send me some comments or feedback on anything else you'd like to hear. Thank you very much.